I'd like to get started, ladies and gentlemen. Before we begin, I want to recognize our past review council and directors. Put up your hand if you once worked at CLS. Those of you, look at that. Look at that. That's great. One of our former directors, Michael Cormier, was here earlier today, and regretted he couldn't stay. By the way, if any of you are tweeting about our symposium, the hashtag is A2J Symposium. And we've already got a number of tweets online as Pascal looked them up for me. I want to introduce Tom Conway to you. Tom was first elected as a bencher of the Law Society of Upper Canada in 2007 and re-elected in 2011. And he was elected as the 64th Treasurer of the Law Society in 2012 and re-elected last year. He's held many high-profile positions as a bencher, including Chair of the Professional Development and Competence Committee and Co-Chair of the Retention of Women in Private Practice Working Group. He's currently Vice President and President-elect of the Federation of Law Societies of Canada. He served as this I think says a lot about him, he served as a cross-country ski coach for the Ontario Special Olympics. I first met Tom when he chaired the Articling Task Force, which I know, Tom, was quite the experience for you. And I see Tom as a reformer in the best definition of the word, with a strong dose of common sense. He has a vision of where the profession needs to go to ensure it has a bright future. And Tom Conway is the first treasurer to make access to justice a top priority. He appointed the Treasurer's Advisory Group, which has made recommendations to Convocation on a new approach to access to justice. Ladies and gentlemen, the Treasurer of the Law Society of Upper Canada, Tom Conway.
Thank you very much, Doug. Merci de cette aimable présentation. Je vous remercie de m'avoir invité à la réouverture de votre clinique et à parler à l'accès à la justice. Thanks for inviting me to the reopening of the clinic today and to speak to you a little bit about access to justice. The Community Legal Services Clinic at Western Law, like all of the university legal clinics, provide important opportunities for community members to obtain much-needed assistance and opportunities for law students to learn and experience the ethic of public service that has infused our legal profession since its beginnings. And at community legal clinics, students see firsthand the challenges people in this province are facing in accessing justice in 2014. You see how problems compound and how they escalate and overwhelm people, and you see the relief and hope that even just a little amount of information can help. It's important work, and it's a valuable service to the community. So congratulations on your reopening and for dedicating the necessary space to expanding the needs and the programs that you offer to the public. So I was asked to speak a little bit today about the Law Society's approach to access to justice. And this has been a priority for me during my term as the Treasurer, and I hope that before I leave the office in June, that the Law Society will have adopted a new and invigorated approach to access to justice issues, that this new approach will enable the Law Society to foster greater collaboration and innovation among the professions and among a broad cross-section of partners who can effect change, including the Legal Academy. But let me back up for just a moment. Just over a year ago, I established the Treasurer's Advisory Group on Access to Justice, which we gave an acronym called TAG. We have acronyms for everything at the Law Society. And through TAG, I began discussions with a range of justice senior sector partners from groups whose core mandate includes providing access to justice to representatives of the courts administration and to government, to the bar and paralegal associations, and to legal aid and so on. And I was seeking advice and input into how the Law Society might enhance its role on access to justice issues and to foster change, real and substantive change over time. Now, many people actually questioned why I was doing this. The Law Society, after all, is the regulator of the professions. It's the gatekeeper, if you will, to the professions, people told me. And we are, it is said, steeped in tradition. We're removed from the day-to-day issues people face and slow, if not resilient or resistant, to change. And our core functions, I was reminded, and I didn't think I needed reminding, but our core functions are to ensure that lawyers called to the bar in Ontario are competent and that they conduct themselves professionally and ethically. And some suggested to me that our role, if we had one at all in access to justice, was quite narrow. But in 2007, our legislative mandate changed, and I think it was a profound change. In carrying out those core functions that I just spoke about, of ensuring professional competence and conduct, we were, according to the legislative amendments, to do so in a way that would, quote, facilitate access to justice for the people of Ontario, unquote. So now, this principle was added to the Law Society Act at that time, largely to recognize the Law Society's new role of regulating paralegals in the province. But as we have watched the access to justice challenges continue to expand, many of us believed it was time to consider what more the gatekeeper could be doing in response to these challenges. So before I go on, I must emphasize how proud I am of the Law Society's long-standing interest in and commitment to access to justice. From the early 60s, when the Law Society worked with the Ontario government to establish the Ontario Legal Aid Plan, which the Law Society then ran for many years, as many of you will recall, to today, which sees the Law Society maintain a standing committee on access to justice, the Law Society has occupied itself to some greater or lesser degree in the, quote, access to justice, unquote, portfolio. The Law Society's current Access to Justice Committee has worked with many, many organizations in the development and delivery of unique educational and pro bono services and other initiatives. And this history of commitment and achievements has positioned, I think, the Law Society to now take on an enhanced role, to do more to facilitate access to justice and to foster the necessary change and collaboration that so many have been speaking about in recent years. The discussions we have had through TAG over the last year have convinced me that the Law Society is actually uniquely positioned to take on a new role, and that there is widespread support for us to take on that role. And this has led to a report that Convocation will consider later this week. And that report recommends that the Law Society do two fundamental things. One, that it fully integrate the consideration of access to justice needs and objectives into the core business and function of the Law Society, as it ensures that professional competence and conduct of lawyers and paralegals, and two, that it provide, and this is important, that it provide the infrastructure to support a standing forum for collaboration on access to justice issues here in Ontario. And so, what will all that mean? Well, with regard to the first, integrating access to justice needs and objectives into the core business and functions of the Law Society, we are proposing to Convocation a framework within which we would take a hard look at lawyer and paralegal regulation, and we would examine the rules of conduct and practice restrictions, both existing and proposed. And within the framework of what we have proposed, the Law Society would consider strategically and systematically the extent to which lawyers and paralegal regulations in and of themselves create barriers for people in accessing legal advice, legal services, and legal information. So where possible, we need to consider liberalizing our rules and our regulations. We need to make it easier for people to get the legal advice or the legal information that they need. So put another way, the Law Society needs to constrain the unauthorized practice of law in more consumer-friendly ways. And that requires us to look at the legal information, legal advice divide. What advice must be provided by lawyers or by paralegals, and where is there potential for needed information to be provided by others, such as paralegals, or by even trained non-lawyers in some cases. The framework we have put forward would see the Law Society considering increased opportunities for paralegal services, increased legal information services by lawyers and possibly by qualified non-lawyers, regulation with respect to outsourcing of legal services, regulations with respect to the provision of summary advice and referrals, among numerous other steps that we could take to streamline regulations and rules within our own professions. We'd also like to look at competence from the perspective of facilitating access to justice and changes to legal practice and service delivery. What skills and what knowledge become necessary in this changing context is the question we have to ask ourselves. As rules and practices change to accommodate access to justice needs and objectives, legal education and continuing professional development must also evolve, and we will consider those changes very carefully. The Law Society has also been looking at new approaches to practice, such as alternative business structures, that should be considered from an access to justice perspective. There is real potential, for instance, for alternative business structures to free lawyers to do what they do best and let others, non-lawyers, manage the business side, finding efficiencies, being innovative, and reducing costs to clients, thereby making legal advice more acceptable. And there are examples of what the Law Society, within its regulatory mandate, can do to foster change and innovation and facilitate access to justice. In fact, many of these considerations have actually been recommended by others, such as the Canadian Bar Association's Reaching Equal Justice Initiative and the National Action Committee on Access to Justice in Civil and Family Matters. This menu of action items makes our job at the Law Society easier, in a sense, because so many others have already looked at these issues and have identified practical and meaningful responses that are very similar in nature. And these and other reports have also recommended breaking down the siloed thinking on access to justice issues and facilitating greater coordination and collaboration amongst the profession, the justice sector partners, and others who provide critical service for people trying to access justice. And the need for greater coordination and collaboration, which we also heard this past year during our TAG dialogues and conversations, led to the second fundamental recommendation in the report currently before convocation. And that is that the Law Society provide the infrastructure to support a standing forum for collaboration on access to justice in Ontario. And there is momentum now that I don't think we've seen before. It seemed that everywhere I turned this past year, people were echoing over and over and over again the need for greater collaboration and the need for facilitated leadership. There is a recognition that we can achieve so much more together than we can separately. And together we can eliminate duplication, leverage resources more effectively, and create that common voice that we've lacked for so long to create an agenda for further change. But collaborative efforts most often fail because of a lack of infrastructure dedicated to supporting that work. And this is where I believe the Law Society is uniquely positioned to make a substantial contribution. In creating TAG a year ago, I found out very quickly that when the Law Society calls on people, people come and they respond. From key leaders and policymakers within the government and within the courts, to academics, to lawyers and paralegal associations, and indeed many members of the public. And they have largely supported the idea that the Law Society maintain this forum to facilitate this ongoing collaboration that will be required to achieve long-lasting results in the Access to Justice file. The Law Society has the resources and the expertise, I would say, because we have no particular agenda of our own, and we have the necessary neutrality, I think, to bring parties together and maintain this momentum. So while the report to convocation proposes that the Law Society provide the facilitation and infrastructure support to the forum, it is by no means suggesting that the Law Society would dictate the forum's agenda. That would be developed by the forum's participants. And together they would consider their shared vision and the common agenda for change. And it's expected that participants would then translate the vision and the agenda into specific actions and strategies to be implemented by participants in their respective spheres. And in addition to infrastructure support to the ongoing administrative needs of the forum, the report to convocation recommends that the Law Society also support a regular symposium. And this symposium would be convened by the forum as an opportunity for the forum to report on or to report out on its activities and to maintain momentum and continually seek to expand its reach and its influence. So these are proposals. There are obviously many details that remain to be worked out of the report should it be approved by convocation this week. But if it is approved, this commitment would mark a very significant first step in realizing the recommendations that so many have made in the past year or so. And I think the Law Society would and should be very proud to make this kind of a contribution to the access to justice challenges that we face. Alors, nous en sommes encore au début, mais c'est un début très excitant. Il y a une volonté de passer à l'action et de collaborer. Ensemble, on peut faire beaucoup. En collaboration, le barreau peut plus aisément remplir son mandat de réglementer la profession en favorisant l'accès à la justice pour la population de l'Ontario. So, as I've said, these are extremely early days, but they are also very exciting days. There is a will to move forward from talk to action and a will to work more collaboratively together. And together, much more action is possible, and working together, the Law Society can better fulfill its mandate, its legislative mandate, to facilitate the professions, to regulate the professions in a way that facilitates access to justice for the people of Ontario. So I was invited here today in the spirit of collaboration, and I thank the organizers for that and for recognizing the need to seek and contribute to the greater coordination and collaboration, and I look forward to that continuing. I do want to acknowledge some of the criticisms that were made earlier of the Law Society, but one of the best pieces of advice that I got when I was first elected treasurer was from a lawyer from the Ottawa Valley who called up, and known him for years, called up, left me a message. He says, "Tommy, you got to understand that now that you're the treasurer, you are the fire hydrant in the dog kennel." So you just have to stand there and put up with it. It's not my usual disposition, but I would love to hear people's questions and comments, and especially those from the panel. Thank you very much.
Perhaps Tom, would you take a couple of questions or attacks, whichever comes first? Any questions for the treasurer? Yes, sir.
We'll try this again. It was so much fun the first time. Tom Chalmers.
It's a great name, don't you think?
Pardon me?
It's a great name, don't you think, Tom?
Anyway, I've read the report and the draft resolution for convocation, and I thoughts gone through my mind. As a sole practitioner in rural Ontario, I lived through a bunch of these changes. One was the report on the small practices, that came and went, made no difference in my life, and in fact, what difference it made in anybody's life? In the small practices, they're still getting grayer. In fact, your predecessor, Laura Polizza, was down to talk to Kent at the dinner, and she brought the stats for Kent and said, good news, there is no crisis in Kent. 70 or 75% of the profession there is over 50 or 55. We're past the crisis. The last one, the croak, please turn out the lights. So that initiative what's it done? The civility initiative of 2 treasurers ago, Derry Miller, it's led to the chill coming out of the Grolian matter. So that's reverberating. So, is this initiative just, and I'm not trying to be miserable here, but is this just one more thing, another bureaucracy, more of this bunch of things, but is it just maybe going to be more of I'm from the government, I'm here to help type of thing? It's a great initiative. I'm not, when I say these comments, I'm saying it without trying to demean the spirit of it, but I'm just wondering if you're trying to do a top-down thing, for people like me, and what difference could it make?
Well, first of all, the sole and small firm practitioners report was published around 2005, 2006. Its focus was actually on the bar. It was on the sole and small practice bar, and it was in addition to sort of studying and researching and analyzing the predicament of soles and small firm practitioners, which still make up most of the practicing bar throughout the province. It addressed a number of issues. And recommended, for example, that there be a council at the Law Society devoted to soles and small. And much of the recommendations have actually been implemented. If you take a look at the sole and small firm practice report and some of the recommendations, they have been implemented in one form or another. They haven't been enough, perhaps. But this Access to Justice initiative is actually much more broadly based. First of all, I think the plight of soles and small firm practitioners is an issue that the Law Society has to be constantly concerned about, and it's a conundrum, and it's a difficult, challenging issue, and that's why we're actually some of the reforms that we're doing at the licensing level, for example, we hope over time will address those issues. But I think it would be naive for anyone to say you could snap your fingers and then all of a sudden we're now going to have lots of people practicing in the smaller towns and so on. I think these are problems that are complicated and require a number of different strategies. But I think this initiative, and to your point, I understand your point, and I am concerned, to be quite candid about it, that this won't end up being just the flavor of the week. And that is why, together with the CEO, we've implemented actually the kind of structural changes that are needed for the Law Society to assume this role right now in a more effective way. In fact, Grant Wedge, who's here, has just been hired as the executive director for corporate services and so on, and he's got an extensive history within government on access to justice issues. And so we're getting ready for this new role that we'll play. I've been hoping that what I can do as the treasurer is really, if I can, to the extent I can, convince convocation, to convince guys like Mike Lerner that we're here, and who's still here, and I don't need to persuade Mike, but to persuade Convocation that this structural change needs to be hard-baked into everything we do, so that we will basically have three pillars of activity or operation. One is competence, the other is discipline, and the third is access. All I can do is hope that people agree with me and that it becomes, it becomes an important activity that the Law Society goes forward with in the next, for the next generation. We'll see.
Pascal and Fred have to catch a flight, so again, thank you folks for coming. We really appreciate it. One of the things that I heard loud and clear when I went to the Access to Justice Summit in Vancouver last year, this is a quote from Justice Cromwell, that the justice system is like a body without a head. There's no one directing mind. That's one of the difficulties we encounter in implementing proposed reforms to access to justice. But we're going to talk now about what we can do here in London to promote access to justice. It's chaired by Professor Stephen Patel of Western Law, and our panel members are from my left, your right, Bill Woodward, President of the Middlesex Law Association, Jason Voss, Review Counsel at CLS, Justice Linda Templeton from the Family Court here in London, Stephen's in the middle, Mary Potter, Crown Attorney for the County of Middlesex, Justice Jeanine Leroy from the Provincial Court of Justice, and Janet Froud, who is the District Area Director for Legal Aid Ontario. Stephen, it's all yours.
Thanks very much, Doug. Thank you very much for the invitation to be here and to chair this second panel of the day. I teach and research, I guess, in two areas that involve access to justice, namely civil procedure and legal ethics. According to Doug, that qualifies me to moderate this panel, if not to make any substantive contribution whatsoever to the dialogue and discussion. We're going to have a panel discussion focusing on what could be done here in London as initiatives to improve access to justice. Our panelists are all, so to speak, on the front lines of our justice system, and we hope that they will be able to draw on their own personal day-to-day experience and share some of that with us today. We've worked out some of the ground rules beforehand. Each panelist will speak for 5 minutes, ruthlessly enforced by me, in the order called upon by me and established by me. That should then leave us 15 minutes for questions from the audience. You will see somewhat thematically that we will start with some criminal law issues and then move into some family and to some civil law issues. And so to kick us off, we'll start with Justice Dineen Roy.
Thank you. And I want to publicly say congratulations to Community Legal Services. I have always been, I hope you think, a big cheerleader for Community Legal Services, both when I was in practice and now that I have the pleasure of being on the bench. And I can't say enough about what kind of experience CLS gives to law students. I will tell you that although I didn't have the pleasure of attending this university or this law school, sorry, I did go to a school that had a legal clinic, and it was the best part of my legal education. And I always say that it, in great part, made me who I am today. So keep it up. I hope today to briefly tell you about 5 things I think the Ontario Court of Justice is doing well with respect to access to justice, 5 things that I think we could really do better, and 5 miscellaneous ideas that I have sort of thought of in the last few days and today being here listening to the other speakers. I won't dwell, so it's going to be sort of a list. We'll take questions at the end. The first topic is the 5 things I think we're doing well. The Ontario Court of Justice has a purpose statement, a vision statement, and both of those include direct mentions of access to justice, and it informs how we view our court. We are, with all of the greatest respect to the lovely judge who I love at the other end of this table, we are the front line for criminal work in our province, and we are committed, according to the purpose statement, to providing accessible justice that is timely and effective. And it is part of our vision statement to continue efforts with respect to improving access to justice. So we don't have a choice. We need to be part of the solution. The second thing I want to say is that a number of our Ontario Court judges sit on provincial committees that are already working with this issue, both on a judicial level and with the Law Society and with other stakeholders. I really hate that word. But we're already involved in coming up with practical solutions. The third thing we've done is we have created a guide for unrepresented accused who are going through both the criminal trial procedure and or the provincial offense trial procedure. And while it's certainly not 3 years of law school distilled down to 16 pages, it is our effort to try to provide them with a guide through the system and how to, if it comes to that, to conduct their own trial. The fourth thing I think we try to do well is our pretrial system. It's also going to be, ironically perhaps, one of the ways I think we could do better. But the part that we do well is that we do allow lawyers to have their pretrials by telephone. And I can tell you that because of recent conversations with one of the previous speakers, I informed my staff, to the extent that anyone listens to me at all, that we will be doing those by Skype if the lawyer wants it done by Skype. We have some issues with respect to pretrials when the accused is unrepresented. We need to make sure those are on the record, and we're going to do our best to make sure that we can do that by phone. Why we require people who are lucky enough to have a job, frankly, in this economy, to come to court numerous times, and one of those times is for a pretrial, is beyond me. They should be able to ask their employer for a 15-minute break so that they can have a conversation by phone with us. That's my view. And then finally, the fifth thing I think we try to do well, and for sure we aren't always successful, but those unrepresented accused, ultimately, if they're having a trial, are doing it in front of us. And while we're not allowed to give legal advice, we are required to make sure that that unrepresented accused has a fair trial. And we learn subtle ways of providing advice through that procedure, and it's a very difficult line that we have to walk, and I'd like to think that we do that well. We'll see. So those are the 5 things that I think we do well. There are probably many more than 5 that we could do better, but I'm going to highlight 5 of those for you now. The first is what I'm calling e-docs, but we have an e-doc thing in the works, but it's really for our system. It's for judges to have their orders printed out in a courtroom. That'll help. Anyway, it will help some things, but it won't help the accused. For me, it is crazy that that person cannot have access. Oh my gosh, 30 seconds. Can you tell what I did for a living before I became a judge?
At least you started with the good thing.
Yes, exactly. So we need to have access for people to get their documents online. A subpoena, a request for a pretrial. You've got to be kidding that you have to come to my courthouse in order to get those things. Those should all be available online, and we're going to need to work with Ontario Court Services and the ministry to make that happen. You should be able to file those things electronically. You should be able to set dates electronically. That we can't do that in 2013 pisses me off. Oh crap, I forgot we were being recorded. More than you know. It is unbelievable that we can't do that. And we need to have more meaningful pretrials, which means we need to have, frankly, better training for judges in mediation. The rest of the world is going that way. Criminal judges need to go that way too. 80% of what we do does not go to trial. Most of what we do should be mediated, and we don't frankly know how to do that. We were great negotiators, we're not great mediators, and we need to learn how to do that. And finally, it seems to me that in London we need to have local focus groups, or maybe I'll call them exit pretrials. It's never occurred to me to ask an unrepresented accused how I did, or not how I did, but how the system did for them at the end of the trial. I don't know why, I'm embarrassed why that hasn't occurred to me before, but maybe we need some law students to help us come up with some real data for London and not rely on the provincial statistics to get data about what the system was like for them. I'm going to shut up. I'll leave the 5 for later.
Our second speaker is Mary Potter.
Like Justice Leroy, I send congratulations to CLS, and I did go to this fine law school, and I also worked at CLS, so I am a big fan of what's done, and I am hoping that despite what Jason Voss may say about the problems faced by students, I hope that our office is found to be very supportive of student clinics. I'll say this, I think that 25 years of practice has shown me that the number of accused people charged with criminal offenses who really want to negotiate the criminal justice system on their own is a very small percentage. Unfortunately, in recent years, there have been many more who go all the way through to trial on their own. I even see now in the Superior Court people who are trying to negotiate on their own. And that, you know, there are people charged with very serious sex assaults, robberies, all kinds of offenses, and they don't have counsel, they're trying to launch appeals, and they're just not able to do it. And so I really think we need to help people negotiate through the process, and anything that student clinics can do to assist, I think is great. There has been a focus the last number of years under the leadership of Attorney General Chris Bentley and his successor, Garrison. Certainly, the focus has been on justice on target, streamlining the criminal justice system, making it more efficient, making appearances in court meaningful, getting to the end in a more timely fashion, getting disclosure to people accused earlier, having access to the Crown attorneys reasonably, and you know, when it needs to happen. And it is difficult when people are not represented by counsel to have that work efficiently and effectively, because disclosure, for example, generally it is electronic now. Accused people, we do paper disclosure for them. Having meaningful pretrials, having meetings with counsel is difficult. As Mike Lerner said, you know, there need to be facilities at the courthouses where people who aren't represented by counsel can go to negotiate with crowns and things like that. One of the things we're doing in London is we're trying to expand on the role of these students, something that's been initiated by CLS, brought to my attention, and I took it to the Justice of the Peace Bench, is to have the assistance of students in the Peace Bond Court. It's a court that runs every Friday. Emotions run high. Everyone really feels strongly about these matters in this court. And so the students have kindly offered to become involved in mediating between these parties so that you don't have these hearings that can go on for hours without resolution. So I would say that that is a great step in the right direction. And anything we can do to involve students more is good.
The third speaker, again sticking still with the criminal law system theme, is Jason Voss.
Hi, everybody, and I want to begin by just thanking everybody for being here today. I've been a lawyer at Community Legal Services for the last 15 years, and I'm also an adjunct professor of law here at the faculty. Most of the courses that I teach are clinic-related courses, so they're related to what we do in our clinic. And from the bottom of my heart, I really thank you for all being here today. This is a very important issue and an issue that's near and dear to me. I'm happy to say that we're able, through Community Legal Services, we're able to service a few hundred accused persons here in London each year. And that's through the efforts of the staff at Community Legal Services, but primarily through the efforts of the students. So I want to congratulate the former students that are here today to lend their support, and the current students, because we could not do this without. We provide service, we do trials, we do appeals, we do guilty pleas, we do resolution meetings with my friend Mary at the Crown Attorney's Office. And I want everybody to understand that the people that we're representing, the people that we're providing service to, each and every single person that Doug mentioned, the 1,000 that we put through each year, would not have access to legal service without our service. Okay? because these are people who are not eligible for a legal aid certificate, and these are people who cannot afford a lawyer. I didn't look at the statistics, but I would venture to say that most of our clients are existing on what many of us would make in a day or two per month, okay? They're existing on $800 to $1,000 per month. So I think we provide a real service and a real valuable service. That being said, I think that we have some barriers here in London that hinder our ability to provide greater access to justice for people in the London community. And I wanted to highlight, I've got 3 topics. I wanted to touch on the courts, I wanted to touch on the government, and I also wanted lastly to touch on the law school itself. And I do have some criticisms of the court and the Crown Attorney's Office, but please take them as constructive criticisms, because Mary is a very good friend of mine and a former colleague.
He warned me this was coming.
And I did.
I'll protect you.
So, and a lot of this ties into what we spoke about earlier. Really, it's the debate between, do we want a system that focuses on the system itself, or do we want a system that focuses on the people that are trying to use that system? Okay, and so I think a lot of my comments will tie into that. Here's one way that I think our courts could be more accommodating to allow greater access to justice. People are brought, if you're charged with a criminal offense in London, Ontario, you're given a court date according to the first initial of your last name. So for example, if your last name happens to be Brown, your court date is going to be on Tuesday. Each and every subsequent court date beyond a trial or a guilty plea, you're going to have to appear on Tuesday. It doesn't really matter if you have a job, a part-time job, and you've got to be there on Tuesday mornings. You have to be in court. If you're not in court, there's going to be a warrant out for your arrest. If you're a lawyer and you're trying to organize, or a law student, you're trying to organize your day, your practice, in the past, when we had some flexibility in when we set dates, we could say, for example, Thursdays are going to be my day when I do the majority of appearances in court. So I'm going to try to adjourn all of my cases to a Thursday. That's not possible now. So how does that affect a student legal aid clinic? Well, all of they're law students. They're not just clinical students. They have classes, okay? So I can't tell you what a nightmare it's been ever since the Crown Attorney's Office implemented the alphabet system to try to match students who are available on a particular morning with accused people who need representation, okay? And what I'm saying is, if the system were a little more flexible to allow adjournments on days that might deviate from that person's last name, then we actually might provide better access to justice. I don't think there's any cost for doing that. Secondly, resolution meetings. If you want to have a resolution meeting with the Crown Attorney, sorry, I have 30 seconds, then you have to go down to the courthouse and you have to fill in a form in a book. That works very well for friends like Mr. Dobson, defense counsel, who are there every single day. It doesn't work well for law students who may only have 1, 2, 3 files and who may only be at court every once, 2 or 3 weeks, okay? They've got to go down to court, pay for parking out of their own pocket, book a resolution meeting, and then come back to the office. Not terribly efficient. Something I think we could change, and again, that would not present much of a cost. I'll skip what I was going to say about the government. Lastly, I think the law schools itself. We're here talking about access to justice and how law schools can improve on that. I'm here to say the battle isn't about improving on it. The battle is maintaining what we have, okay? I can't tell you, most of the service that we provide in criminal law is through the courses that I teach. My students are required to carry files in the clinical courses that I teach. I teach them how to do interviews. I teach them how to do various advocacy activities, okay? And there's debate among and in the law schools about either eliminating or rotating those courses. So from my perspective, we need to just maintain what we already have to ensure that we're at least providing what we are right now in terms of access to justice. Thank you very much.
Thank you, Jason. We then come to Janet Froud.
Hello. I'm going to be speaking primarily about family law access to justice issues, which we haven't touched upon yet, but also I think there is quite a bit of overlap between family law and criminal law when it comes to how the problems could be approached to improve how the system works for the client. There definitely is an access to justice problem in London for family law clients. Our first point of access at Legal Aid for clients is the advice lawyer in the Family Law Information Center, and more than 50% of clients who come to see that lawyer do not actually qualify even for that service. And that is our most generous test. That means they definitely cannot qualify for a legal aid certificate, and they definitely cannot afford to hire their own lawyer. So, well, a few of them can afford to hire their own lawyer, but we see many, many people who cannot, who realistically cannot. So Legal Aid has taken some steps to try and improve access to justice here in London. We have some changes that we're in the process of implementing, and we have some plans for the future. And if my talk goes like the others, you'll never hear about our plans for the future unless you talk to me afterwards. So I'd be happy to talk to people afterward. But access to justice, we've talked mostly about financial access, I think, here today, but there's another aspect to it. There's geographic and physical access to justice. And there's also the impact of other barriers like learning disabilities and mental health issues. And a good justice system has to take all of those into account because all the clients are different and have their own issues. Legal Aid here and in other centers has spent quite a bit of time analyzing what we can do with public money that would be the most cost-effective way to help the greatest number of people achieve a just outcome. One of the things that Legal Aid has been thinking about is what can be done by non-lawyers to supplement lawyers' work. And we have already, we have an extended duty counsel program here in London, so a great number of people are helped through that. We have had the advantage of a pro bono students program for several years that help the students go in rotations and help clients complete their paperwork under supervision of one of our lawyers. And also over the past 2 years, we've added 2 legal aid workers. And what all of these people do, the students and our non-lawyer staff, are assist the clients with referrals to other resources because no one comes in with just one problem, and with information about the legal process, and with document preparation, which is very key for a large number of clients struggling with the forms that one deals with in family law. Legal Aid has received 3-year additional funding from the provincial government, partly for family law initiatives. We held consultations across the province, including one here in London, with stakeholders. Some initiatives have been developed already. One of them is addressing geographic and cultural barriers to access to justice. We are creating situations where clients can speak to a lawyer outside of the courthouse setting. So clients who are early on in a family law proceeding, for example, who do not have to come in to this courthouse in London to speak to a lawyer. These 2 of them are on reserve projects. We've established an advice clinic on the Oneida Settlement and the Muncie Delaware Reserve once a month. We also have established family law advice lawyer availability at Neighborhood Legal Services, the local community legal clinic. Aside from geographic and cultural barriers, there are, of course, the financial barriers that have been the focus of this discussion. Here is where family and criminal law come together. We've already heard that the vast majority of cases end up resolving and do not go to trial. How do we help the parties achieve the things that they expect from the justice system? A fair outcome, opportunity for input, to have their rights and interests protected, and to get to that resolution point as soon as reasonably possible. In our view, it benefits no one to have a matter drag out. At least that is not justice for a matter to drag out. On the criminal side, really?
No. You take all the time you need.
I'm going to skip the criminal side. On the family side, London is one of 14 pilot sites for a mediation support project. And this is already just launched. We now are able to provide 6-hour authorizations for lawyers to advise unrepresented parties before and after mediation. So if parties are interested in mediation, they're unable to get to the point of settlement themselves in a family law matter, and they are unrepresented, we are using a more generous financial test than we usually do, and we will provide each lawyer with 6 hours to speak to the client before and after mediation in the hope of arriving at a enforceable agreement.
Thanks very much. We then carrying on with some of the family law themes, we move along to Justice Linda Templeton.
Thank you for inviting me. I've spoken on access to justice many, many times, and I have emphasized the following. Access to justice is entirely different than access to a judge. And there's got to be an understanding of that. We can talk about access to justice, but a lot of people on the street will think, well, that means getting to a judge quickly. And when we address access to justice, then we've got to understand that we're not talking about access to a judge. And because of that confusion, the blurred lines, all of our courtroom doors have been absolutely flooded with people expecting justice when they've bypassed the system, and the system itself hasn't rendered justice. So I see two concepts that cannot be confused. A couple of lawyers in here will tell you, well, even if they get in front of me, they won't get justice anyway, so it doesn't matter. But I see them as different. Talking about access to justice involves the system. And two factors have completely exploded upon the system, within the system, and have put incredible burden on the system, which is not functioning well from a family law perspective, from the judicial perspective, and that's this. One is the volume of litigants. The number of litigants are exploding. And two, the impact of the economy on those litigants means that they're coming in self-represented. So those are the two factors. People are litigating more, and the economy is driving the fact that they can't be represented. How does the system fail them? Well, right now what we're trying to do is triage. But we have to triage at the courthouse door, not at the courtroom door. So we're going at it backwards. We need to triage right before they get to the courthouse at 80 Dundas Street. We have to identify for people, or help them identify, what are your issues? And what are your expectations from the legal system? And this is where students come in. A fellow or a man or a woman might be talking about access, but they're arguing custody. They might be talking about how much they want to see their children. They don't necessarily want to make the decisions, but they want to see their children. They can't identify the issues because they don't know what the issues are. They do know what their emotional response is to the problems that they're facing, but they can't identify the issues legally. The second huge problem that I find is preparation of documents. So here's what happened, and this was pointed out in black and white before me about a year ago. It was put down, she'd been in the legal system, in the family court system for almost 2 years, comes up for a summary trial in front of me. No one is on the other side. I look at her documents, I look at the application. She's expecting me to render justice. It's gone swimmingly. She's seen counsel from time to time, but she's done it on her own. She's navigated herself. And I see in the application, all right, I'm about to give a final order, and I say, well, can I just ask you a question? And she said, yes, Your Honor. I said, why are you granting custody of your children to your husband? And she said, I'm not. I said, well, that's what you've asked the court for. She said, I just want support. Nothing in her documents, in her pleadings, indicated a claim for support. The only thing she had checked off was she saw the reference to children, so she checked off children. And in fact, she sought a custody order giving her husband custody of the children. She'd been in that system for 2 years, and that was the pleading that she'd served on her husband, so no wonder he hadn't responded. All right? We had to start the system all over again. So that's why I say access to justice is different than access to a judge. Because she's not had justice, and yet she's been in the system. So issue identification, we need to get that sorted. How are we helping these people with respect to identification of their issues? How are we helping them with respect to preparation of their documents? All right? I can't give custody orders. I can't give exclusive possession of a house if you don't ask me. And you have to notify the other side. I had one today. She had personally served the husband 6 months ago. Not allowed under the rules. You have to get somebody else to serve. So we have to start all over again. And in the meantime, she's bouncing back and forth. She has no idea. All right? So issue identification, preparation of documents, then we get to advocacy, and then we get to understanding of consequences of the settlement of the order. So I say access to justice means triaging at the courthouse door, not at the courtroom door. And you do it 3 ways: issue identification, and preparation of documents, and then finally opportunities for informed resolution. And that's one thing we are doing now. Case conferencing, settlement conferencing, trial management. We've got all these steps. So there are lots of opportunities for informed resolution, but we have to know how to help these people get there properly.
Thank you. And then our final speaker, taking us over to some of the civil law side, is Bill Woodward.
Good afternoon, and thanks for sticking it out. As last person on the docket, I guess I get unlimited time.
Yeah, nice try.
I am a graduate of this law school. I was a CLS volunteer, and I also participated in the London Legal Clinic program, which was held downtown when I was here. And they were terrific programs, and I can tell you that virtually all the students that participated got articling jobs and were typically hired back at their firms, so keep that in mind. I do insurance defense work. I actually do try civil cases when I get the opportunity, which is not very frequently, and there's a number of reasons for that. I think the message that has come to you loud and clear today is the system is crumbling, and if we don't do something, it will fall down around us. I think the biggest factor is that there are more cases being added every year to our lists than can possibly be disposed of by the courts. And Justice Templeton's comments are well taken here. As a result of that, there have been a number of changes that have largely developed voluntarily. People have become much more accepting of mediation as a form of resolution, and the vast majority of my cases typically go to mediation voluntarily. Cost has become a huge factor and a huge wall for people to access justice, and we've heard that many times today. And as I heard Mr. Heaton speak earlier and sort of said, you know, we each of us individually has to do something, you're faced with this daunting task and this huge system that all these smart people in this room haven't quite figured out how to solve. And I thought to myself, what can I do as an individual? And one of the things that occurred to me in listening to the speakers today, and something that frustrates me oftentimes, is what I call unintended consequences and the impact that has on our system. So when I started out, I would have a file with Michael, a typical personal injury file, and it would consist usually of a traffic report and maybe one letter from a doctor. And we would meet and we would resolve that case for probably $5,000 if he was having a good day. And I was being more generous than usual. We now have a system of legislation for personal injury cases for motor vehicle accidents that requires you to prove a permanent and serious impairment of an important bodily function. Net result is that I don't get a file in like this. It comes in about 4 banker's boxes. And we have multi-week trials instead of one-day trials. And the cost to the people involved in that system is huge. It's not unusual for there to be $40,000 or $50,000 spent in just disbursements, fees for experts, reports, assessments, and it just continues to grow and grow. So how do we fix that? Well, I think part of the process has to be all of us keeping an eye on the ball and looking at these unintended consequences. So the government's idea with this new legislation was, let's get rid of all these small claims. All that really has happened is that a lot of those small claims that we could dispose of on a summary basis with a meeting between 2 of us over a cup of coffee have now developed into these huge files at great expense to the litigants. So some of this involves our political decisions and the legislation that's coming down the pipes. Our rules amendments, oftentimes very well-meaning. Perfect example, a number of years ago, there was a decision in Windsor to try and clean up their list of cases that had been initiated but weren't on a trial list. So the edict came down and said, we want all those cases on the trial list within a year. They went from a very manageable caseload of maybe 1,200 cases on the trial list to over 5,000. Justice Templeton, if she'd been sitting, would have gone berserk, I'm sure, because you don't have the judicial resources to deal with that many cases. So again, somebody well-meaning thought this is a good way of moving cases along instead of sitting on our list, and created a disaster for themselves. 30 seconds already. Michael made a comment earlier about having to attend at court. We've instituted in our rules a requirement that clients attend civil pretrials. The vast majority of times they sit out in the hall for 45 minutes. But to me, that's a huge waste of those people's time. I can communicate with my client, and I'm sure the other lawyer can, about what we've discussed and what the judge's recommendations are. So those are just a few things that I think we as lawyers practicing in whatever area, when you see a problem like this developing, that some well-meaning person in Toronto or in Ottawa thought would help the system, we need to speak out. We need to involve ourselves in forums like this and the forum that our treasurer has talked about earlier today. Write those letters to our members of parliament and members of the legislature. Chris is shaking his head, don't do that. But we do need to involve ourselves and get the message out. Thank you very much.
We have a few minutes for questions. I'll take questions. I would ask that you identify yourself and that you identify the target or targets of your questions.
Chris Dodson, I'm a criminal defense lawyer, well known to some of the people up there. So what I would say is when you're talking about access to justice, you have to worry about the rush to justice. You have to worry about the quality you're getting. The things that I hear here today is we can use paralegals, we can use students. I think it's great that we can use those people. But what are you getting? And we can get rid of litigants, get them out of the system. Well, do we want them out of the system? What are we trying to teach them about justice? What do we do with people who have lengthy records and we simply divert them to get rid of them? I mean, those are, what are you teaching those people? What are you teaching your community? But I watched, really concerning to me, my main concern, as some of you know, is mentally ill accused. I watched a mentally ill accused do an assisted guilty plea with duty counsel, told they were getting a conditional discharge. They got a 10-year weapons prohibition order on top of a conditional discharge. And it wasn't even argued against. Was that justice for that litigant to get a 10, because I can tell you the RCMP doesn't remove that record of that weapons prohibition order for another 10 years. 20 years on a minor offense could have been diverted. Nobody, that person had counsel, but did they have justice? No, they didn't. And that's my concern about underfunding litigation, not making sure people are taking the time to get the proper legal advice. And not only that, but they are told in an informed way what they're stepping into. There's no way that litigant knew that they were actually going to have a record that's going to stick around for 20 years. So rush to justice is not access to justice. So I'm making a statement, not really asking a question, but it really concerns me. You know, I don't like the dentist. I don't like going to the dentist. And I don't like when the hygienist lines me up for an x-ray I don't need. But I have a little more information. When I've got a litigant who's a vulnerable person, they need all the information they can get, whether they're going to jail or not. And my real concern is the number of lawyers that are being taken out of the process of access to justice. Because my concern is they're not going to get justice.
Thank you for that comment. Any other questions? Right here.
I'm Alexandra. Just in terms of technology and systems, not that I'm holding up Florida as a great standard, but their system of e-filing and holding motions even by telephone and teleconference is already in place. So we're not reinventing the wheel. So I don't know if anyone's looking to these other jurisdictions where these processes have been implemented to see what's gone right, what hasn't. And, you know, like I said, we're not reinventing anything here.
You'll find that, if I can make,
Of course.
you'll find that most of the, certainly the front line, like the judges and so forth, have attended international conferences or attend conferences involving other jurisdictions. And we have had so much exposure to other systems that are working well, but we're not in the decision-making process, in position to be able to say, okay, this is what we're going to do, this is going to work. For example, Sydney, Australia, I was there last year at an International Family Law Conference, New South Wales. A judge doesn't see anyone unless they're going to trial. And that litigant has been through everything and had professional services. I mean, it's a purist system, it's wonderful. It works incredibly well, but we don't have the funding here and we don't have the political resources here. So that's a huge, I see that as a big barrier for us.
You don't have to go internationally. We have nationwide conferences, and almost every jurisdiction, frankly, does it better than Ontario. In Vancouver, or in BC, if a judge in northern BC finishes their list at 1 o'clock, and you might be surprised to learn that happens, they can help by starting a trial that's going on in Vancouver and that had been waiting all day to get a judge, because they can do video trials. It's not hard. We need a government with the will to make it happen. I'm sorry to be political.
Okay, the feed in my ear from Central is telling me that I need to throw it back to our host, Doug Ferguson. So please join me in thanking our 6 panelists for their contribution.
Well, it's been a remarkable day, and thank you again for coming. The video feed will be up on Vimeo. We will make sure that we send everyone a link so you can watch it on your own time later on. I hope there's a desire to continue to do something locally. I don't know if there's any committees that have been set up in the various courts or through the MLA, but if not, perhaps that's something we should be exploring. We've been urged by the CBA to think systematically and act locally, and I think now is the time to act. So thank you again very much, and have a great evening.